is it okay if we take the public hearings first? Because that's what people would be here for.
Yeah, absolutely.
All right, all right. Am I good in the back? All right, seeing that it's 6:08 on Tuesday, January 7th, 2025, I'll call the Town of Webster Zoning Board of Appeals meeting to order. Please be advised that this meeting is being recorded. And if you want to see a copy of it, it's on YouTube within a couple of days. Out of concern for the public, we'll take our public hearings first, just because that's where the public's able to interact with the board. And that's what I'm assuming most people are here for. So we'll do the special permit application for the construction of a garage and porch at 252 Thompson Road. Mr. Daggett is not here, the clerk, so I guess I'll read the warrant. So in accordance with the provisions of the Webster zoning bylaw, section 650-11B, the Webster Zoning Board of Appeals will hold a public hearing on the special permit application for the extension of a pre-existing non-conforming garage and front porch located at 252 Thompson Road, Assessor ID 33A70. The application was submitted by Ken LaRose, 252 Thompson Road, Webster, Mass. Applicant owner. Said site is located in the business district without sewer, B5, and watershed protection zoning districts. So the way the public hearings work is the town will, Ms. Morgan will give a report from the town on the application. The applicant's allowed to present their application. After the applicant's presented it to the board and fielded questions from the board, will allow input and comments from the public. There's no inter-parties communication during the hearing, so all questions that the public may have about an application has to come through the chair. And finally, once the public comments have been exhausted, the applicant will be allowed to make give a closing remark. And after the hearing's closed, there's no other information that's be allowed to be accepted. So I say that because I see that there was some correspondence on the 67 Wawila Park Road. So, but the first one we'll take is 252. So, Mr. LaRose. That's you, sir, please. Yep. Yeah. Yeah. Actually, Ms. Morgan, would you care to give a report from the town?
Sure. I'm just pulling
Yes.
up onto the map. Oh, jeez. I think I can learn how to spell. Okay. So there were no comments from, when we sent out a request for department comments, the responses we got were no departments had any issues or concerns. This is the existing house. And this is, no, that's not right. Is that 252? Are we at 252? Yes. Just want to make sure I get this right. 252 Thompson. There's the aerial photo. This is what they're proposing right now. They want to fill in this corner. So that's why they need a special permit, because this is a pre-existing non-conforming setback. Okay. And there was really nothing complicated about this application, and I'll let the applicant go from there.
Sure. All right, sir, please. Yeah, would you just mind turning yeah, just turn it on. That's all it has to do. Yep, you're good now. You might want to talk into it, otherwise they won't catch you on the recorder.
My name is Ken LaRose, and we had just purchased a home at 252 Thompson Road in May, and we're liking to make the renovations to the home. The garage is very shallow. It's not very deep for a pickup truck or a large vehicle, so we'd like to extend that back to the rear corner of the building so that we can fill that space in and use it for additional storage. And also like to put a front porch on, farmer's porch style. I don't know if you have the drawings in front of you.
I see a garage. Where is the porch located?
So if you're looking at it from the
We
street,
have a what your plan on our screen in front of us.
Yep. So if you're looking at it from the street, it's the back left corner of the garage that we'd like to extend to the rear of the home, within a foot of the back line of the house.
So I see, maybe you could clarify this for me, because I see the proposed addition in the back.
Yep.
Would you mind coming around and pointing that out? So we have,
Right here is the rear of the home.
Yep.
Looking at it from the main street, and this back corner of the garage doors here.
yeah. So you're putting, the addition is only for a deck? Did I hear that right?
For the what?
A deck? Or,
No, this is a garage extension.
okay, so you're extending the garage and you said a porch.
In front of the building, there's the farmer's porch. I don't know if I have that.
Yeah, as long as that's not into the setback, so you're not expanding a nonconformity. So let's say the reason why you're required for a special permit for this is because you're expanding what's already in the nonconformity. So if this porch is more than 10 feet away from the sidelines, which is what I believe the setback is, then you can do it as a matter of right.
So it's basically just the back of the
Yeah, that's all we're concerned about. The porch is, that wasn't raised, and, yeah, that's not shown on the plan, so. Unless the building commissioner said differently. No, okay. So you said the setback is 4.1 feet from that corner?
Correct. Yes, when it gets constructed, it will be 4.1.
1 feet. And the existing is maximum of 4.4?
The front corner, yes.
Yes,
Front
okay.
left corner.
Um,
The house must be set at
Yeah.
a little bit of a skew to the property line.
So this is expansion of the garage, so there's going to be no other people living in there. It's not going to create any unnecessary congestion of population. There's a number of different considerations. This isn't going to strain municipal
There'll be no plumbing.
facilities. Okay. How tall will it be?
How tall?
How tall will it be? Yes.
So it'll be no higher than the existing ridge that's here.
Yeah.
It's going to be a slope roof to the rear.
Yeah.
So we'll end up framing up over the back of that garage that's there now.
Yep. Although I believe you're telling me the truth, one thing we do that I put on for our applications, because if we allowed it, you could go up to 35 feet.
Right. No, that's not my intention.
It's not your intention,
Yeah.
but if we allowed it, it'd be a matter, you could do it as a matter of right. And one of the considerations that we have taken into consideration is blockage of air and sunlight.
Right.
So as a precautionary matter, what we'll likely do, I can't speak for the other members,
I don't know
is
if you saw
is put a height limitation. Is that,
I don't know if you saw the next pages back. Is that available to you? So it's not going to change the view from the street?
yeah. Yeah, but what I'm getting at is we'll likely restrict your maximum height.
Yep.
I don't see that plan in front of me. Yeah, all I have is your plot plan. So what would that height be?
At this actual point here, it's probably
Or maybe we do have
more
it,
than 20 feet.
20 feet?
And the house might be 25 to the ridge.
Okay. So 20 feet would be sufficient?
Be the maximum.
The maximum, okay.
Yep.
Okay. Any other questions from the board? None? Any questions from the public? I have none. Actually, before we continue, Ms. Dimick Mahaffey and Mr. Chikowicz, they're on the application, right? The hearing? Okay, yeah. Yeah, they're appointed as members, voting members for this one. So we have a full board. I just wanted to make sure I did that during the hearing. Otherwise, if I closed it, then it would be only have a, you could be, only have three persons deciding this. All right, is there a motion to close the public hearing for 252 Thompson Road?
I'll second the motion.
Motion is second. Any discussion? Hearing none. Ms. Morgan, can you please pull the board?
Mr. Mason? Yes. Mr. Chahowski?
Yes.
Mr. Fails?
Yes.
And Mr. Piattar?
Yes. So there'll be a decision prepared for our February 4th meeting. We'll decide your application then. You're welcome to come and observe, but there won't be any, we won't be able to take any input from you from now until that point. So, okay, that's it.
That's when you make the decision?
That's when, yeah, then there's an appeal period of 20 days
Mhm.
from when the decision's accepted by the town clerk, and Ms. Morgan can take you through that procedure.
When you were reading it originally, did you say it was not on sewer? Because it is connected to town sewer and town water.
That's what I was going through the considerations, but I can't really go back into, since
Just
we've already
wanted to
closed the
clarify
hearing,
that
yeah.
It is on town water and sewer.
Yep.
Okay,
Yeah, I think
Should I shut
I
that
heard
off?
you. No, leave that on,
great.
because we have one more public hearing.
Thanks for your time.
You're welcome. All right, variance application for a new garage within the front and side yard setback at 67 Wawila Park Road. Reading the warrant, in accordance with the provisions of the Webster zoning bylaw, section 650-11C, the Webster Zoning Board of Appeals will hold a public hearing for a variance application for relief of front yard setback and side yard setback requirements to construct a garage located at 67 Wawila Park Road. Assessor ID 62E70. The application was submitted by Michael Hopkins, 8 Walters Drive, Oxford, Mass., and David Candow, 67 Wawila Road, Webster, Massachusetts, owner. Said site is located in both Lake Residential and the Lake Watershed Protection Zoning District.
Mr. Chairman, before you move forward with any action tonight, you will need to appoint voting members.
Okay. I appoint Dimick Mahaffey and Mr. Chikowicz to this application.
Okay. The applicant did submit a letter to withdraw without prejudice. I know you've got at least one neighbor in the audience who has been following this and did submit comments, just so you're aware of that. It's my understanding that they're going to go in a different direction, likely to be back here with a different type of request for zoning relief, but
Okay.
this particular application, they're not wishing to pursue.
Okay. I see the request, since there is a member of the public here. If you want to speak on the application or the request, I'll allow it. No? Okay. All right. My inclination is to grant the request to withdraw without prejudice. It doesn't gain them any advantage to do this. They would just have to come back and pay all the fees. So is there a motion to?
Well, you should close the hearing first.
Okay. Close the hearing. Is there a motion to close the public hearing for 67 Wawila Park Road?
I'll second the motion.
Motion is second. Any discussion? Hearing none. Ms. Morgan, can you please pull the board?
McHaffey? Yes. Mr. Mason? Yes. Mr. Fails?
Yes.
Mr. Chahowski?
Yes.
And Mr. Piattar?
Yes. Okay, now we can accept or deny the request to withdraw the application, correct?
Correct.
Okay, is there a motion to accept the applicant's request to withdraw the variance application for 67 Wawila Park Road without prejudice?
I'll second the motion.
Any discussion? Hearing none, Ms. Morgan, can you please pull the board?
McHaffey?
Yes.
Mr. Mason?
Yes.
Mr. Fails?
Yes.
Mr. Chahowski?
Yes.
And Mr. Piattar?
Yes.
Okay.
All right. So it's withdrawn without prejudice, so they have to start the process all over again.
We knew that, I just wanted to see our town at work.
All right,
Wanted to observe your board.
all right.
Thank you very much.
You're welcome. Thank you. All right. All right, back to the top of the agenda. We'll take our draft meeting minutes from November 20th and December 10th. Those,
Those were distributed. I
Yep.
received no comments.
all right. Is there a motion to accept the draft meeting minutes from November 20th and December 10th?
I will make the motion.
I'll second the motion.
Motion is second. Discussion. Hearing none, Ms. Morgan, can you please poll the board?
Mr. Mahaffey?
Yes.
Mr. Mason?
Yes.
Mr. Fails?
Yes.
Mr. Chahowski?
Yes.
Mr. Piattar?
Yes. All right, draft decision, the modification.
Well, did you
of-
want to do the December meeting minutes, or was that motion for?
That
That was for both.
Oh,
Yeah.
thank you.
Yes.
One and done.
One and done, thank you.
All right. Do we have a quorum on the draft decision for My Shed?
This question's going to come up for all four of the decisions. For this, for 91 Bates Point Road, the people who are eligible to vote are let's see, you're not eligible to vote, Jason. Dan's not here. Chris is not here. You do not have quorum to make that. Mark was not present at the hearing, but you have until February 1st to make a decision on this, which means you would have to schedule another meeting.
Yeah. I don't know if it's appropriate for me to say what the lawyers would do, but I think we could, I could have a extension signed,
Um,
because otherwise it'd be granted as a matter of right.
That's correct.
Okay.
So my advice would be for you as the applicant to come sit out here
Yep.
and let, who's your
The board
next?
discuss.
Actually, you don't have any other officers, so it'd be up to Mark or Dan as to who would like to run the meeting from here.
Mark would be our senior member.
All right. So, the good news is with this decision, Mark can sign a Mullen certification and become eligible to vote because you weren't here on the 20th, but you have reviewed the meeting minutes. So that would be the first thing that we would do as staff is to get you that certification. The next step would be for the applicant to agree to extend the decision deadline.
Okay.
So, and the decision would be for February 4th, but that extends it to not only you making a decision, but a decision being filed with the town clerk, which can't be done that night. So you would ask the applicant to agree to extend the decision deadline to the 11th, at which point I would send the form to him for signature, which I would file with the town clerk, but you would need a verbal request from him tonight to extend the decision deadline. Due to, these are sort of extreme circumstances, you have a sick member and another member who couldn't make it. So I think it's appropriate for you to ask the applicant if he'd be willing, and then you would take a motion on that and vote on that. So at that point, for that next meeting, the only people who will be eligible to vote would be Dan Canoyer, Chris Daggett, Dan Fales, and Mark Mason. Because the hearing was closed, you can't appoint either the alternate members, so you're going to need
Do you
all
need me
four.
to say that?
No, it'll be in the record here because it's
All
being
right.
recorded.
Okay.
So we'll do that. So as the acting chairman, you would ask the applicant if he'd like to come forward and agree to extend the decision deadline to Tuesday, February 11th.
Okay. Mr. Taylor, would you like to come forward?
Yes, I'd like to extend the decision deadline to February 4th.
11.
11th, I'm sorry, 11th, yeah.
So you agreed to extend the decision from till February 11th, and I'd like to make a motion.
Well, you don't have enough voting members for that. The fact that he's agreed to it and will submit a signed form
Okay.
makes it active.
Right. Thank you, Jason.
Okay.
All right. Draft decision, variance application for construction of the two-car garage at 60 Colonial Drive.
Okay. Eligible to vote tonight on this is Jason. Dan's not here. Chris is not here. Dan fails. Mark could mullen in, and both Jeff and Kathleen were present at the hearing. So, and your deadline for making a decision is February 8th. And your next meeting is the 4th. So your option is to try to invoke the rule of necessity to appoint, but you'd still only have 4 voting members, which is still not in the applicant's best interest, I personally think, but you can proceed. And because you do have time in February to take this up, then the rule of necessity isn't really valid
Right.
because you've got the opportunity. So you would have to put this on the February agenda.
Yep, February agenda. So I do see the applicant here.
It's not up to the applicant. You
Yeah.
can't even get
No,
insight.
no, no. I mean, for an extension of the deadline.
Well, they don't need it because
need it?
you
Okay.
have until February 8th to make a decision,
Okay.
which means if you make a decision on the 4th, I get it to the town clerk before
Okay.
the 8th.
So there's still time then.
There's still time.
Okay. We'll see you on the 4th then, Mr. Pelletier. All right, draft decision, side yard setback for the new garage to existing house at 222 Lower Gore.
Okay. Eligible to vote tonight, people who are here would be Jason, Dan, Mark, and who was the appointed 222? Let's go.
I think that one was Jeff.
I couldn't remember if that was Jeff or you. Jeff, so you have 4 voting members here tonight to take that up.
Okay.
The deadline for making a decision on this one is January 30th.
January 30th. Okay, so let's, if we have enough members to vote, then I think we should take it up.
Okay. I did not bring my printed copy for this, so we'll go through this on the screen. My apologies. So, well, you'll see here in yellow, at the time of decision, this will now reflect the 4 members who are here tonight eligible to vote. Here are all the documents that were submitted. Findings of fact, obviously anything in yellow is going to be adjusted. The applicant's requesting a attached garage to an existing single-family house. Only the garage needs a side yard setback requirement. Side yard setback in the agricultural single-family residential zone is 15 feet, and they would like to be 2.6 feet from the property line. All the required documentation had been submitted. None of the town departments that responded had any issues or concerns about the project. During the public hearing, Mandy Hicks of GBI, Guaranteed Builders Incorporated, represented the applicant, and they went through it. This reflects the meeting minutes. This all came out of the meeting minutes. And it talked about the fact that they wanted a two-car garage attached to the house on the left-hand side. And you discussed with her, what about your other options on the other side and topography? So, what is a hardship? The other conditions for granting were also reviewed. It's a single-family house in a single-family zoning district where garages attached and detached are common. The next-door neighbor, Lauren Angel from 224 Lower Gore Road, was present as well. She raised some concerns that weren't in the purview of the board in terms of the use of what's upstairs, but was concerned about the impacts to her quality of life of that being so close to the property line. And then those are the boards, the departments that submitted comments, no comments, and no other comments from the public. So now you get into the conditions for granting. So you'll get into unique site conditions. You need to make a finding and then make a decision.
All right. Is there a motion to accept findings F1 through F10 as presented?
I'll make that motion.
Is there a second?
I'll second that motion.
Motion second. Any discussion? Hearing none. Ms. Morgan, can you pull the board?
Mr. Mason?
Yes.
Mr. Fails?
Yes.
Mr. Chahowski?
Yes.
And Mr. Piattar?
Yes. All right. Unique site conditions based on soil shape topography. I think the applicant raised topography as their concern. I think if you, from what I've seen, and I believe we discussed this with the applicant, I don't see topography being greater on the left side of the house versus the right side of the house. The shape of the lot is similar to other lots in that area. They're triangular shaped. Would it be an inconvenience for the applicant to have their garage on the opposite side, where they have 43 feet? It might be inconvenient because their driveway would lead directly into their, Ms. Morgan, could you bring up the plot plan on there?
Sure.
Yeah. Perfect. I think it would be an inconvenience for them to move their driveway to the other side, but to create another nonconformity, because what's ideal to the applicant, I don't think it meets the unique site, meets the unique site conditions in my mind. I think they also have space in the rear of the lot. Again, not ideal. You might have a longer driveway, but and also, or in the rear of the house, there's a shed there. They could stay off of the septic area. It's a septic area. It would just take some minor creativity in my mind. So I will find, for those reasons, that the applicant has not demonstrated unique site conditions. Would anybody else care to make a finding of their own? Hearing no other findings, Ms. Morgan, or is there a motion to find that the applicant has demonstrated there are special circumstances related to unique site conditions?
I'll make that motion.
Is there a second?
I'll second that motion.
Motion and a second. Any discussion? Hearing none, Ms. Morgan, could you please poll the board?
No.
Mr. Mason?
Yes.
Mr. Mahaffey?
I'm not on the
Oh,
list.
I'm sorry. Mr. Piattar?
No.
No. Who's the last one?
Jeff?
Thank you. I'm working off of an old position there. Mr. Chahowski?
No.
Okay. So motion failed.
All right. Literal hardship how enforcement of the front and front yard setback would, and side yard, actually it is just a side yard, would cause a significant financial hardship, financial or otherwise. Because I didn't find unique site conditions, I can't find that these unique site conditions would cause a significant hardship, financial or otherwise. As I stated, that I believe the applicant has significant space on the other side of the house, and moving the driveway may be a inconvenience with this, given the space that's available. I don't see where that would rise to a significant hardship. Would anybody else care to make a finding of their own? All right. Is there a motion to find that the applicant has demonstrated that there is a significant hardship, financial or otherwise?
I'll make that motion.
I'll second.
Motion second. Any discussion? Hearing none. Ms. Morgan, can you please poll the board?
Mr. Mason?
No.
Mr. Fails?
No.
Mr. Chahowski?
No.
And Mr. Piattar?
No. Public good, how desirable relief may be granted without substantial detriment to the public good. Remember what the criteria is for the public good. I know the question I always ask is the use allowed? I'll find that it could be, relief could be granted without detriment to the public good because garages are an allowed use in the town of Webster. And also that the use of a garage for residential purposes wouldn't create any excessive noise, dust, or debris. Anybody care to make a finding of their own? Hearing none, is there a motion to find that the applicant has demonstrated that relief can be granted without a substantial detriment to the public good?
I'll make that motion.
I'll second that motion.
Motion is second. Any discussion? Hearing none. Ms. Morgan, could you please poll the board?
Mr. Mason?
Yes.
Mr. Fails?
Yes.
Mr. Chahowski?
Yes.
And Mr. Piattar?
Yes.
Okay.
Last but not least, can relief be granted without nullifying or derogating from the intent and purpose of the Town of Webster zoning bylaws? Kind of piggybacking off of the public good, I'll find that it can because garages are allowed in single-family residential areas. And allowing a person to have one on their house doesn't derogate from the purpose of the zoning bylaws. Would anybody care to make a finding of their own? All right, is there a motion to find that the applicant has demonstrated that there are unique site conditions?
I will make that motion.
Or I mean, not unique site conditions, sorry, I was reading off the screen. That relief can be granted without nullifying or derogating from the intent and purpose of the Webster
I will make
bylaws.
that motion.
I'll second the motion.
Motion is second. Any discussion? Hearing none. Ms. Morgan, could you poll the board?
Mr. Mason?
Yes.
Mr. Fails?
Yes.
Mr. Chahowski?
Yes.
And Mr. Piattar?
Yes. Before we decide whether to grant or deny with the conditions, I would remind the board that this is an and statute. So meaning that it's, if you, in theory, voted no on one, you must have all four. You must have yeses in all four columns to have the variance granted. So you have to have unique site conditions, hardship, public good, and zoning. It can't be two out of, three out of one, because if you don't have one, then you can't have the rest of it. It's not an or. Is there a motion to grant the variance application with conditions?
I will make that motion.
I'll second.
Motion and second. Any discussion? Hearing none. Ms. Morgan, can you please poll the board?
Mr. Mason?
Yes.
Mr. Fails?
Yes.
Mr. Chahowski?
No.
And Mr. Piattar?
No.
Denied.
Okay. Is there a motion to direct Ms. Morgan to sign the decision on our behalf?
I'd like to make that motion.
I'll second.
Motion is second. Any discussion? Hearing none, Ms. Morgan, can you pull the board?
Mr. Mason?
Yes.
Mr. Fails?
Yes.
Mr. Chahowski?
Yes.
And Mr. Piattar?
Yes. Draft decision, front yard setback for 76 Lower Gore Road.
Okay, your deadline for making a decision is tonight, but you do have 14 days to file with the clerk after this. So you're within your rights. Eligible to vote, Jason, Dan, Kathleen, and Mark. I'm sorry, my mistake, because you did not, you were not here on December 10th. And unfortunately, neither was Mr. Chahowski.
Except for he already mullined in on that one.
Beg your pardon?
I thought he mullined in on that one.
Did you give me documentation for
Yes,
that?
it's up on the website. I saw it earlier.
Oh, let's go double check that, because sometimes. Okay, because that would then give you at least voting membership. What are we looking at here?
Stamp received today, but you know,
Yes, but when I meant back through the voting,
yeah.
he missed November as well, and you can only miss one. So that was my mistake. The one that we needed Mark to sign the Mullen certification for was 222 Lower Gore Road. So,
Mr. Mason is on, there is a Mullen for him for 76 Lower Gore.
yeah, but he also missed the November meeting as well.
Okay.
You can only miss one. So that was my mistake. So,
Then they get it as a matter of right,
well,
or because
you could, I think I may have brought some blanks. If not, I'll have to go get them. Yeah, you can't, because you didn't appoint them as voting members. I don't know enough about the rule of necessity, if you can appoint them at this point. Because you only
yeah, I
have,
don't know the case law enough to,
you only have 3 voting members then, so you don't have enough to make a decision. You need
Yeah,
4 out of
I
5.
think I would lean towards, they get it as, I'm blanking on the language, but we're not able to vote on it.
You can't, and you can't request of the applicant to extend because they're not here.
Yeah, I think invoking the rule of necessity without us or myself being completely sure about it, I think it opens us up for needless litigation if it was challenged. So saying that we aren't going to get an answer on that tonight, I don't believe we should decide the variance application for the detached garage. I don't believe there was any negative comments received from any of the neighbors.
No.
Personally, I don't believe it meets the variance criteria, but because we don't have enough voting members to confidently vote on it, I don't believe we should make a decision.
You can't make a decision, so going forward, due to lack of voting quorum, I submit a memorandum to the town clerk's office cataloging what happened here tonight,
Yeah.
that due to illness and
Yeah.
lack of, voting members. And that goes into the record,
Yeah.
and then I just send out a notification to the applicant that it was constructively approved.
Constructive approval, that's the
Yeah.
term I was looking for.
Yeah, so,
Yeah, the facts worked in the applicant's favor for this one, so.
It's unusual. I've
It
never
is.
seen
It's
you
not
guys do
something that we should make a habit of, but I know that sicknesses do happen, especially in the winter, so. All right, so 76 Lower Gore Road has been constructively approved. Last item is Cronin versus Vinton, 16 Robinson Street. Seeing that's on our agenda, I will try to give a brief, or give you an update from memory. So this goes back to 2017. The company I work for is being sold, so I haven't had a lot. I'm in the process of typing up a timeline because Mr. Mason, myself, and Miss Morgan were here back in 2017. So I want to get you everybody else up to speed because there's two applications, but it's the same set of facts. So the applicant wanted, which would have been the Vintons, they constructed the garage they submitted an application for a variance to construct a garage that was rectangular shaped. That was actually denied, and one of the rear corners of it was 7 by 16. So they constructed a garage in the L shape. The Cronins took issue with that still. They challenged the original variance application and they took issue with what was constructed. So they made several, and there is significant animosity between the neighbors. So when they come before us on February 4th, expect it to be I would say hostile.
Contentious?
Contentious, there you go, contentious hearing. Yeah, so that's what I'm referring to. That 10 by, I think it's 10 by 12, or that yellow corner was denied in 2017 in August. So what they did was they constructed the garage in an L shape. The Cronins took issue with it. There was an issue of a fence that the Vintons built in between. They put up they had a 6-foot fence built, which is allowed, and then they put some plywood on top of it to make it roughly 10 feet, I believe. The building inspector ordered them to take it down. The Cronins also challenged that it needed a special permit because back then the town of Webster had the 25% rule that you could expand in a pre-existing non-conforming structure by 25% as a matter of right. And there was also that whether the pad, because they poured the pad underneath it, whether that constituted a structure. Yeah, there was 3 issues. I think the pad might have been, it was basically whether or not a building permit, it could have been, no, there were 2 fence issues, I'm sorry. They put slots in the fence too. So the Cronins challenged that the fence caused safety issues because the fence extended towards the road. So there was 3 hearings on that in 2018 on the appeal from the building inspector. We took testimony from the police chief and Mr. Tatro, who was the building commissioner at that time. We upheld 2 of his decisions, that there wasn't a safety issue caused by the slots and that were placed into the 6-foot fence, and that the building permit had been issued correctly by him. We reversed his finding on the plywood on top of the fence. He said it was not a problem. However, the applicant produced, or the Cronins produced evidence and statements that a building permit is needed to construct a fence exceeding 6 feet in height. So the Cronins were not thrilled with, or not, weren't happy, obviously, if they appealed that. That's the decision that's being appealed. It isn't a 2017 decision, it's a 2018 decision that's appealed. Stating that to the land court that the garage was granted, yeah, if you can see, you can kind of see the L shape there on our screen. That the garage required a special permit because it exceeds the 25%. That was appealed to land court. The land court found in 2020, people may remember, I know Mr. Mason, you were here. I'm having so many mental lapses tonight. Mr. Fales was here for that, for those hearings on Zoom where we tried to pull out
This is the percentage
the
of,
percentage, right. And we had 2 to 3 hearings where the court remanded it back to us to say, all right, ZBA, you did not find what the dimensions of this new garage are. I found, the judge found certain dimensions. We took testimony. We agreed with him on some. We disagreed with him on others. You may remember the line that the judge from the remand where he said, show your math. I know Miss Morgan, maybe she still has nightmares from doing the math in that one. A lot of geometry. So we showed our math to the court. It was appealed to the same judge. Again, the Cronins amended their argument and appealed it on 2 things. The first issue is that the Cronins are saying, or stated, was that we didn't include the entire garage, and it's unclear from the bylaw that was in existence. Now, this bylaw has been changed. This 25% rule doesn't exist anymore. Whether it included the entire garage, including the portion outside of the setback, or whether it included only the portion inside the setback. The second argument was whether Chapter 46, Section 48, Chapter 48, Section 6 allows for detached structures in the town of Webster to be to have special permit protection. And the judge has remanded that to us, and that's what we're going to hear testimony on in the 4th of February, is to find whether or not the entire structure should be considered. And the attorneys will argue. I asked Ms. Morgan to provide testimony from Mr. Tatro, and if need be, we could possibly, or maybe also take testimony from the current building inspector. But there, in the minutes, there is some testimony that I saw today from, Mr. Tatro, where he did comment on whether it should be the entire structure or not, or just a portion of it that's inside the setback. So that'll be a decision for us to make. So we have to make findings as for statutory interpretation. So we're getting into the meaning of words. Placement of,
Go back to the aerial photo. I just wanted to point out that when you go to the applications under review, this is spooky.
It's been driving me nuts all
I'm like,
Yeah.
I've watched too many horror movies. If you click on the appeal tab, you'll see the 16 Robinson Street links, and one of them is not working, which I'll fix. My advice is to go read through the 2 decisions for sure, and call either Jason or myself if you have questions. We're going to have some very significant guidance from town council on this. This is some of it's way over my head, but she's still working with the applicants and the judge to define the scope of what exactly you're going to be asked to make a decision on. So you want the aerial?
It's most recent photo, how about one prior to the structure being put up?
All right, so this is 2023. Do you want me to go back to a different layer?
Yeah, go back,
Okay.
2015, please.
2050, because that structure was put up on.
Oh, that's pretty.
Well, that's helpful.
Let's see if 13's better. All right, a little better.
Yeah, I don't want to have too much discussion.
Yeah, you don't want any discussion
Too
on
much
it.
discussion. This is more or less just an update of what happened, what's coming. I don't want to dive too much into this because both parties are represented by two, in my opinion, two very good land court attorneys. And these parties, this has been going on 7 years. I don't want to give them an extra issue for appeal that, could drag us
Back into
greater.
this again?
Well, we're being dragged back.
I know,
into it.
but again, after this next round.
So Ms. Morgan and I, we did meet with counsel and we are trying to get clarification as to what the land court judge is asking us to decide, because we thought we had decided everything properly back in 2020. Apparently we didn't. And I'd rather not have this come back. So, there will be, I'll send out a timeline just for the members that aren't here so that you can also, the refresh your memory is, what happened with, in the course of events. There are minutes from all of those. Ms. Morgan, maybe, you could send just that section of those minutes out to the board.
Yeah, no, those are all in PDF format. So I'll send the meeting minutes and the decisions. As you know, the decisions typically cut and paste what's in the meeting minutes as well.
Yeah, there's a
So-
lot of discussion in the 2018 appeal where they talk, or at least Mr. Tatro talks about, what he considered, with what his interpretation of the 25% rule was. So that might give us some guidance, because he's since moved on to Southbridge, and I wouldn't expect him to be present for this hearing because it's going to be lively. Any questions on what to expect? Yeah. So it's been going on for a while, and I'd like to deal with this in one hearing. So come with your questions. That's why Ms. Morgan and I have been working with counsel to get the issues defined, so that we're not caught with a surprise on the 4th of February. So that when we can just have one hearing, let the parties hash it out in front of us, and we can move on.
Okay.
All right.
Well, just one last note from me, and it isn't on the agenda, but it is just an informational piece. The town has entered into a letter of commitment with CMRPC to help draft a draft accessory dwelling unit bylaw for our town and towns around us. And I'll have more of an update for that. Jason was able to help get that ushered through nicely. It was signed by the town administrator, and it was agreed upon by the chairman of the zoning board and the planning board to proceed now that the draft regulations are out from the state. So I'll have an update for you at your next meeting.
Okay, good. That was on my list to ask you about. So good.
All right. Is there a motion to adjourn to February 4th?
I'll make that.
I'll second.
Motion is second. Any discussion? Hearing none, all in favor say aye.
Aye.
Aye. All right. Meeting's